We are happy here at the Partnership for Strong Communities to be hosting another IForum. Today's IForum is an introduction to tenant protections, Connecticut and beyond. We have a great group of panelists and speakers here today to share some great information with you. And we're excited to be together virtually once again, but thanks for joining us here in this virtual setting. A couple of reminders as we start. This event is being recorded and streamed via CTN. It will be available after this as well on the partnership's website. All attendees have entered muted and with your cameras off. If you'd like to submit some questions during the session, please put them in the Q&A box at the bottom of your screen, and we will do our best to feed those to panelists, and we'll have some time for Q&A at the end of our formal panel session. Next slide, please. A quick thanks too as we move along here to our sponsors, CHAFA, the Connecticut Housing Finance Authority, DOH, the State Department of Housing, and the Melville Charitable Trust for their generous sponsorship that makes these types of education sessions available and free to everybody. You'll see some notes on your screen about how to submit questions as well as we move along. Want to note we have our agenda here for today. Opening remarks from me. We have a great keynote presentation. I'll be introducing our speaker for that momentarily. A panel discussion set, as I noted, with some time for a question and answer at the end, and then some closing remarks. Our panel will be moderated today by the partnership's very own Danielle Hughley, and a special thanks also to Kaylee Pratt and Don Branson with the partnership for their support in putting today's event together. I note too, I just skipped over, if folks want to share their own experiences, we welcome shared experiences, whatever that may be, professional or lived expertise as part of this. If you'd like to do that, you can share them in the Q&A anonymously if you so choose. And we will do our best to try to incorporate some of these experiences, if you'd like, into the conversation. Next slide, please. So for those of you who aren't familiar with the Partnership for Strong Communities, a partnership has been around since 1998. We're a housing policy and advocacy organization, and we're dedicated to ensuring that everyone in Connecticut has a safe, stable home that is affordable to them in an equitable community of their choice. And we also wanted to identify some of our commitments as an organization, particularly in the area of racial equity and highlighting disparities, which we'll be doing some of today as well. You can see some of those up on the screen in front of you. Slide, please. Thank you. And now I'm going to be introducing our speaker for today. We're so lucky to have her here with us. Our keynote, welcome. Please help me welcome Marie-Claire Tran-Leong. She will be joining us today from the National Housing Law Project, where she is the Evictions Initiative Project Director and a senior staff attorney. At the National Housing Law Project, she engages in policy and legal advocacy at the federal and state level to prevent evictions and increase tenant protections to help keep individuals and families housed. Marie-Claire has also engaged in extensive advocacy at the intersection of housing and the criminal legal system. More about that in a moment. And she also sits on the board of directors of the National Income Housing Coalition, of which the partnership is a state partner. Before joining the National Housing Law Project this past February, she worked for over 14 years on the Shriver Center for Poverty Law. In her most recent role, she directed the organization's Legal Impact Network, which is a multi-state advocacy network comprised of unrestricted state-level multi-issue law and policy groups working towards economic and racial justice. And before that, she was a senior staff attorney with the Shriver Center's housing team, specifically leading the portfolio on housing access for people with arrest and conviction records. So we're grateful to have her here with us today. With that, I'm going to turn it over to our keynote along with Danielle. So thank you so much, everyone.
Thank you so much, Kylie, for the introduction. And as I kind of move towards sharing my screen, I just want to apologize for being off camera today. Children are back at school, bringing things home. And so it just made a little bit more sense today for me to be off camera. But I'm going to try to make up for it by kind of moving through this presentation a little briskly and trying not to belabor too many points, especially since we have a really fantastic panel that is coming behind me. So I appreciate everyone's patience with that. So again, thank you for having me here today. As was mentioned, I work at the National Housing Law Project, and for over 50 years, our mission has been to advance housing justice for people and communities living in poverty. And a core component of this mission is strengthening and enforcing the rights of tenants. And so I'm really excited to be here today to talk to you about this important issue and to especially hear what is happening on the ground in Connecticut. So for our time together today, I'm really going to kind of delve into kind of three major areas. One is talking about the characteristics of renters and looking at what puts many of them in a particularly precarious and vulnerable positions, especially right now in our housing system. The second is a little bit of an overview of how we got here, I think, really focusing probably on the last few years and what is some of the existing state of affairs, I think, in the rental market that we're seeing at a national level. And then we'll end with a discussion of tenant protections that we're seeing a need for at the federal level, and some of which that could be enacted at the state level, which I hope will be a natural progression to the panel following my discussion. So with that, let's start with the renters. So right now there are about 44 million renter households in the United States. And about a quarter of these, which is about 11 million, have extremely low incomes that are at or below the poverty line. So just for a benchmark, for a family of four, that means living on a yearly income of $27,750 or less. So really not a lot, especially when you think about inflation and the constraints on family budgets right now. And about 71% of these extremely low income renters are spending more than half of their income on rent and utilities. And in the housing space, we call that severely cost burden. And typically we tend to think of affordable housing as spending 30% of income on rent. And so in this situation, again, every dollar really counts. So I want to zero in on some of the characteristics of these extremely low income renter households. And this chart here is taken from the National Low Income Housing Project's annual report called The Gap, which looks at the shortage of affordable housing. And this was released earlier this year. And as you can see here, if you look, a significant number, about 46% of extremely low income renter households are either adults that are over the age of 62, so older adults, or persons with disabilities. Another 44% are comprised of individuals that are in the labor force, working a variety of hours, some full-time and some part-time. There are also a number of individuals that are in school, or there are single adult caregivers, either taking care of a person with a disability or a young child. And so this is just a little bit of a snapshot of who comprises the extremely low income renter households. And for these households, there just simply is not enough affordable housing available. There's a severe shortage of affordable housing in general, and at these lower income ranges, there's not a lot available. So as a result, these households often find themselves in a precarious position in the rental market because they don't have a lot of power to move from place to place, and often are vulnerable to abuses and substandard housing that we've seen. So this is a significant area of concern, I think, for us, where our work really focuses on people living in poverty. So that's a little bit of a glimpse into the renter households and income. There's also what we find significant racial disparities among renters as a whole. So if you look at nationally, so widening the scope a little bit, not necessarily low income households, but really looking at all renter households. You can see here Pew Research had done a study last year where nearly 58% of Black households are renting. Over 50% of Hispanic or Latino households are also renting their house. And this contrasts with about less than 40% of Asian American households and 27.9% of non-Hispanic white households. Now, if you zero in on the renters with extremely low incomes, you can also see significant disparities compared to the general population. Again, according to the coalition's gap report, 20% of Black households, 18% of American Indian and Native American households, and 15% of Latino households and 10% of Asian households are extremely low income renters. And this is compared with only 6% of non-Latino households. And so we see there that there is significant racial disparities. And what are some of the potential explanations for where these disparities might come from? I think a lot of times what we see is evidence of systemic racism in the housing market, but also I think importantly in the labor market, which impacts how much people can afford. So if we look at the labor market, focusing in on Black and Latino households, the median income of Black households is 61% of white households, and the median income of Latino households are about 78%. So there are disparities there. And I think in the pandemic, a lot of this also came to light, where Black and Latino workers were more likely to lose income or employment during the pandemic than other populations. And some of this, I think, we've seen that some of this is due to discrimination against protected classes in the employment space. And some of it is due to policymaking that in the past has excluded significant swaths of workers. So for example, in the 30s, the federal government decided to exclude agricultural domestic workers who at the time were disproportionately Black individuals upon the creation of Social Security. And those type of policies have ripple effects far beyond the time that they were passed. And then I think in the housing space, we've seen a lot of areas where we still see the repercussions today. So redlining is probably one of the biggest examples, I think, of housing, the legacies of housing discrimination, and has contributed to racial disparities in home ownership and a significant racial wealth gap, and making it just a lot more difficult for there to be creation of intergenerational wealth for some communities, and then the ability to own homes, and putting people in a situation where they have to rent mostly. And so we see tenant protections as being an issue very much of income and being able to access income, but also very much a racial justice issue. So where are we right now? And how did we get here? So we, I think for this, I'm going to focus a little bit on the pandemic era responses, but I think for a lot of us who have worked in the housing space for a long time, we know that there have been concerns about protecting tenants that have existed well before the pandemic. But what the pandemic did was really help to focus, I think, the attention of housers and folks outside of the housing sphere on the direct connection between housing and health. So at the beginning of the pandemic, when there weren't vaccines or treatments for COVID, your house was your main source of protection against the virus. So in very real ways, we saw how intertwined our health is to housing. So out of that recognition, we saw in particular the federal government emerge with two of the defining pandemic era policy responses for renters. One is the eviction moratoriums and the emergency rental assistance. So first, the eviction moratorium, there were as a patchwork, very much a patchwork of federal, state, and local eviction moratoria that was designed to keep people in their homes. It was not uniform across the country, and there were definitely places, states, localities that did not create these protections for residents. But what we saw was that it was a really important public health measure where the CDC stepped in to use its power and really solidified that connection between health and housing. Emergency rental assistance was extremely important. The government put in $45 billion to help people. And it really helped tenants in what I consider to be two distinct ways. One is that it helped the tenants to pay the rent that was owed. It, again, was not necessarily comprehensive because I think there were a lot of tenants that were not able to access the funds. But for those who were able to, it helped them to help pay their rent and keep them housed. It also provided an important incentive for landlords to add tenant protections. So, for example, in Philadelphia, which is often touted as a model in this space, they were able to attach emergency rental assistance to eviction diversion programs so that if landlords wanted to be able to access it, they had to engage in mediation rather than take their tenants to court. And that helped to resolve issues and also helped tenants to avoid eviction records that could then be used against them in future admissions. Similarly, there were a number of states and localities that passed bans on evictions while an ERAP application was pending. And so for that period of time, there were some protections against being evicted, which I think was very important for a lot of families. So the distribution of ERAP posed a number of challenges, particularly because it was a brand new program created in the midst of a pandemic where there was no existing infrastructure. But on the whole, it did help, and it helped to create an infrastructure that could be leveraged to create ongoing rental assistance now, which I will return to. So that's a little bit of looking back at the early days of the pandemic. So what is sort of the state of renters now? So the eviction moratoria for the most part ended. The federal moratoria ended a year ago, and the vast majority of moratoria are no longer in effect in any of the states or localities. ERAP kind of depends on where you are. Most places, I'm in California, are at the end. I'm not at the end. I'm reading the chat. Most ERAP, like in California, the applications are closed and they're not able to distribute more, despite the fact that there is significant need. There are some states that still do have applications, and there are potential areas there where those states could leverage those dollars. But for the most part, those have been distributed. And so there's conversations going on at the federal level about an ability to have an ongoing emergency rental assistance program to help renters in various types of emergencies, whether it be disaster relief or other types of unexpected events. So with the end of the moratoria and the dwindling ERAP, what we have seen is a rise in eviction filings. And eviction filings that have reached or surpassed pre-pandemic levels. So to the right of this screen, I have a screenshot from Eviction Lab. And this is the graph of monthly eviction filings relative to the average in Connecticut. Eviction Lab is a source of a lot of great data, not able to kind of take a national scope, but I think for our purposes, looking at it, Connecticut is obviously very relevant. And you can see here that at the beginning of the chart, it looks at January and March 2020. The eviction filings are a little bit less than the historical rate. And they drop in the spring of 2020. It starts to pick up a little bit, but once you get to March of this year, March of 2022, you start to see a huge spike. And ever since March of this year, we've seen in Connecticut a rate of filing that surpasses the historical average. And I think, there are advocates here who understand the dynamics in Connecticut far greater than I do, but I think some of it has to do with a lot of these protections ending. And so we're seeing that in a lot of different jurisdictions, that the end of the moratoria and at the end of the emergency rental assistance has seen an increase in eviction filings. We've also seen this for our work in the public housing space, in the federally subsidized housing space. And that's one area where that is of a special concern for us because we see eviction as being a last resort in the federally subsidized space. And if we see an increase in evictions from public housing authorities and other subsidized owners, what we worry about is that are the tenants who are left, who are evicted, who may not be able to find another place on the market, and also whether a state's homelessness system is able to absorb that many people at the same time. So that's a little bit of context, I think, on what we're seeing with respect some of the impact, I think, of the end of some of these federal protections. At the same time, we're also seeing a dramatic increase in rents. So from July 2021 to July 2022, rents rose by 6.3%, which is the highest rate in over 35 years. Just anecdotally, we have encountered a lot of tenants who are seeing their monthly rents rise by just hundreds and in some cases thousands of dollars. And so I think when we were in the midst of the pandemic, there was a lot of, and it continues to be a lot of worry about tenants being evicted through the court process. But I think equally concerning are tenants who lose their housing because they simply just can't afford the rent anymore. And sometimes renters are on a lease for a year and they can stay in until the end of the year. But there are also a lot of tenants who are on month-to-month leases where there's not necessarily a written lease and the rent can change very, very quickly. And so that's a significant issue that I think that we're seeing for renters. This is also coupled at a time when there is inflation. Now, rising rents are helping to drive inflation. Rents are a significant component of the consumer price index. And so that is part of it. But it's also, I think, thinking about households right now that are trying to stretch their budgets. often it gets taken care of first. And so what's left over becomes less and less to cover expenses such as food, medical care, childcare, and other types of expenses that one shouldn't have to choose between, but that often does become a choice when rent takes over so much of a household budget. The other thing that we're seeing right now is really an increase in um, in corporate landlords, and particularly I think there's been a lot of attention nationally on private equity landlords. Here you can see, and often in these spaces, a straight line between the Great Recession and the current rental market. And what we saw during the Great Recession was that many homes were foreclosed upon during that time and bought up by companies at bargain prices. And what we're seeing now is evictions becoming a part of their business model, where they're much more likely to engage in aggressive tactics to get rid of tenants who might impact their bottom line. So, for example, we had, I think there was the House, there was a report that came out of um, the House of Representatives within the last month or so that detailed information about certain, I think some of the largest corporate landlords of single family rentals in the country. And they were able to get their hands on some emails where management was telling local property management companies ways to get rid of tenants. And it talked about trying to tell a tenant that they were going to evict on a Monday and telling them that on a Friday to see if they would get to leave on their own, or trying to take away air conditioning in Texas in May, or if the person had a child, to threaten to call CPS or to call CPS and make some sort of allegation. And so these type of tactics, I mean, I think for a lot of us, tenants already are in a position where they have least power with respect to landlords. But this increasing presence of corporate landlords is especially concerning because of the potential to really squeeze tenants out of their properties. And so with the end of the pandemic era protections, with skyrocketing rents and inflations, tenants find themselves in an even more precarious position. So, what are the protections that we see as fundamental to their housing stability and necessary to help keeping tenants housed? So, I'm going to go through a few of them here at a very high level. Um, these I consider kind of looking at the tenant protections for those who are currently housed. Just cause protections is something that I think is gaining traction in different jurisdictions, and something that we are particularly interested in the federally subsidized space, because there are some programs such as the low income housing tax credit program that do require good cause before a person can be evicted. And these protections help to prevent evictions that simply there is no good cause. So where tenants I think are most vulnerable are at the end of a lease, where they could be where there could be no renewal, or where there's no fault terminations. So again, I think there are increasing number of localities and jurisdictions that are creating these laws to help tenants to stay housed. The second area that we see is rent stabilization. And this is really to prevent rent gouging and to prevent from unreasonable rent increases. And is something that's particularly important right now, given the skyrocketing rents and the impact that it has on inflation and vice versa. We're also we think that it's very important to have protections against illegal evictions and lockouts. I think during the pandemic, when there were evictions in place, we saw a lot of this from landlords through our network, because maybe the courts were closed, but I think a lot of we heard reports of jurisdiction, or excuse me, of landlords that tried other means of trying to get rid of tenants. And so this again puts tenants in a really precarious spot, because if you come home and then the landlord has locked you out, it just puts people in a very, very tough position, that it's hard to also enforce that right in the courts. The second is habitable property, so including the right to be free from environmental harm and pollution. This is important from a health standpoint. It's also important because there are some landlords, again, who rather than go through the eviction route would allow a property to fall into disrepair in the hopes of getting rid of tenants. And so we think that tenants really have the right to habitable property. Their right to organize. So tenants are realizing that by themselves, sometimes they're not able to affect as much change, but when they band together with other tenants, they can often, especially in large multifamily complexes, their voices are often heard when they band together. So we think it's really important for tenants to have that right and to do so without retaliation. And then finally, freedom from discrimination and abuse by landlords and their agents. Just other basic tenant protections that we see, for the tenants that do face eviction courts, this seems like it should be basic, but it's not guaranteed across the states. Balanced courts and administrative hearings, making sure that folks have due process rights and that they have access to legal representation. And we know Connecticut is one of the states with right to counsel. That is so important for making sure that any tenant protections that are available really get the tenant needs the benefit of that with a lawyer. So, the federal government has a role here. I think the federal government is a landlord or a housing provider itself. There is federally subsidized housing, and that they can leverage these type of protections to the families that are most in need and at highest risk of becoming homeless. The federal government also can tie tenant protections to federal funding. Some of that includes federal grants to state and localities, such as the Community Development Block Grant. And some of it, I think, is through federally backed mortgages. So if the federal government is insuring mortgages, can they add protections in multifamily housing, which is something that we're working on. And then the last thing I just want to mention is around consumer protection. I think that's increasingly an area where we really feel like that there's a need to step in, and that the need to target unfair and deceptive practices by landlords and their agents is really, really important. And finally, just to close, I mean, we focus, I think, a lot on nationally at the federal level, especially because right now there is interest in it. But there is an extreme role for state governments, a really important role. Most landlord tenant laws come out of the state level, and so they have the most levers in this. So what state legislative actions can take place to create tenant protections? Is there a way to leverage tenant protections in state subsidized housing? Because we know there are some states that do provide that level of housing. Can state funding be a potential policy lever? We know that some states right now are considering creating their own emergency rental assistance programs out of various types of funds now that the federal funding has dried out. And is that a way to sort of leverage the tenant protections that people need in this time? And then we're really starting to look at is there a role for state attorney generals to enforce consumer protection laws, and to treat tenants as consumers, and to get the full suite of protection in that role. I'm happy to answer questions, and looking forward to the ways that Connecticut is hearing about how Connecticut is actualizing tenant protections for renters today. Thanks so much.
Thank you, Marie Claire. as you stated at the beginning of your presentation, you set us up really nicely for the panel conversation we want to have. But we do have a few minutes for Q&A. If there are 2 questions, I will throw your way, Marie-Claire, to respond to. But if folks have questions, we do have a few minutes to talk with Marie-Claire before we jump into our panel conversation. But while more questions come through, I'll start with the first one, which is what new legal protections do people with criminal records have effective October 1st, 2022, with the new HUD regulations, process and procedures? And is there a place folks can go to find these new rules?
Well, thanks for this question. It's a really important question. So right now, I think HUD is doing a review of its all of its, as you noted, regulations, processes, and procedures that impact people with arrest and conviction records. I think what will come out of that is maybe some proposals from within the agencies, but I don't know yet whether there will be any changes to what HUD has in terms of protections for people with records. I do think that, in general, HUD has spoken a lot around the fair housing implications of discriminating against people with records, and those continue to be in play. But I think, when the results of the HUD review comes out, it's a really good opportunity for advocates on the ground to hold them accountable to what they have promised to do, which I think in the spirit of that review is to then engage in some actions to address some of the barriers that they found.
Thank you for responding to that. We do have another question. What would the right to organize protections look like? And are there any cities or states leading the way so far in that space? And I'll just note that this is a question we can ask again to our panelists, but wanted to open it up to Marie-Claire for your national level perspective on this.
So I think the biggest protection is to protection against retaliation. So making sure that if you are engaging in organizing, that your landlord doesn't have the right to then put your housing at risk. I do know that New York has a right to organize. I'm not certain about the full contours of that, but that's something that I'm happy to sort of get back to this person about. But, I think from our standpoint, it's really, really important to have this right because, we believe in the importance of lived experience and lived experience informing policy decisions, and also being able to speak to some of the problems that are happening. And so it's really important that tenants are able to organize both to better their conditions within a given jurisdiction and also to inform broader policy.
Thank you. I see one more question. Actually, I see 2 more questions come in, but they're more Connecticut based. So I am going to hold those questions just so the folks who submitted them know for the panelists at the end, so that they can speak to some of the more Connecticut specific questions that you have in the chat. But with that, thank you, Marie-Claire, so much for your time and your attention to both the national work and some of what's happening in Connecticut. We're grateful to have you here, and I hope you're getting a very loud but very silent virtual applause from our attendees today. So thank you so much for joining us. With that, I am going to move us over to our panel conversation. And as Kylie said at the beginning, my name is Danielle Hughley. I am the Advocacy and Education Manager with the Partnership for Strong Communities, and I will be moderating today's panel conversation. Without wasting any time, I want the panelists themselves to introduce themselves to you, and we'll start diving into some of the questions that you're all here to learn some more about. So we do have speaker bios it's a PDF file that Kaylee just shared with you all. If you do want to learn more about the amazing work our panelists have been involved in their lifetimes, but I will kick it off. So without further ado, I'm going to ask each panelist, and I suppose we'll go in order of who's listed first here on this slide, but ask each panelist to introduce themselves with who they are, what your organization does, and what tenant protections mean to you. So I'm going to turn it over to Representative Quentin Q. Williams. Thank you.
So good afternoon, everyone, and thank you for that question. I'm really glad to be here. Once again, I am State Representative Q. Williams from the great city of Middletown, representing the 100 District. I am on my second term, and I am the chairman of the Housing Committee. And I think right now, as we have all gone through a global trauma together, we need to figure out a way to make sure that everyone has safe, affordable housing that they can prosper in and their families can prosper in for each and every person and each and every resident in the state of Connecticut, so that we can have the community that we want and we can continue to grow our economy in a way that everyone could be, I said, safe, healthy, and thrive. In this particular case, what we've seen is housing prices rise where we were already well below the need for housing at all budgets or even affordable housing, to be honest. And we have gone in the right direction, but I think there's a lot of other things that we can do. And I think we probably can save those specifics in a moment, because I think we're going to introduce everyone first, correct?
Yeah, thank you. All right, I'll pass it over to Attorney Kathy Flaherty.
Hi, everyone. I'm Kathy Flaherty. I'm the Executive Director of Connecticut Legal Rights Project, and we provide legal services to people who are eligible for mental health services from the state of Connecticut Department of Mental Health and Addiction Services. That means we represent people who not only live in poverty, but also live with serious mental health conditions. What tenant protections really mean to me and to our clients is all people, including people with psychiatric disabilities, having the right and the opportunity to be able to access decent, safe, affordable, accessible housing in the community of their choice.
Thank you, Kathy. And I'll pass it to Attorney Sarah White next.
My name is Sarah White. I'm an attorney at the Connecticut Fair Housing Center. At the Fair Housing Center, we work on issues related to housing discrimination, both for individuals and to address systemic housing discrimination. We also work with homeowners who are facing foreclosure or have mortgage issues. And then we do community lawyering in support of tenant organizing. I think what tenant protections means to me, kind of similar to what the other folks have said, it's really shifting our housing system. So we're prioritizing tenants' needs for shelter and for a home rather than, making money. I think that means a system ultimately where folks don't have to worry about eviction or rats or getting pushed out or rent increases, where people get to have somewhere to live regardless of what they can afford in a place they want to live. And building stronger connections, with their neighbors because they have that, security. And I think tenant protections are not just one policy. They're what are going to help us move there through changes big and small that address people's individual situations and also give people more opportunity to act collectively as tenants.
Thank you, Sarah. And last but not least, I'll turn it over to Attorney Rafi Podolsky.
Thanks very much, and hello to everybody. My name is Rafi Podolsky. I'm a lawyer with Connecticut Legal Services, which is one of the primary legal aid programs in Connecticut. I am the housing policy advocate and have been for many years. And as a result, have been very much involved in legislation. In terms of what I see as how I see tenant protections, a large portion of what legal services programs do has to do with evictions and making sure that tenants have a fair right to be heard in evictions. In the ideal world of tenant protections, you would never get to the eviction stage. You would not be having people being evicted and having to worry about whether they're going to have to immediately move. You would have the kind of things that everybody else ahead of me has talked about, which is decent, safe, sanitary, affordable housing in which which would maximize stability, and people would least have to worry about losing the housing. Thanks.
Thank you, everybody. So I want to, I know Marie-Claire set a sort of national picture of the experience of evictions and sort of the landscape of it at a national level, but I wanted to open up the start of this panel conversation by asking who is impacted by evictions in Connecticut. And I'll open it up for anybody to jump in.
So I'm going to share a little information just to bounce off of what Mary Claire said. So eviction is definitely a racial justice issue, and it's also, a disability justice issue, and also affects families with children disproportionately. And it does reproduce poverty, structural inequality, and segregation, especially related to race. So in terms of people with disabilities, renters are more likely to have disabilities than homeowners and to be cost burdened with rent, meaning they're paying more than 30% of their income, and are more likely to live in poverty because of the structural ableism in our society. We've seen with the right to counsel data we have so far that 47% of the tenants who are accessing right to counsel say that they have a disability, about half with physical disabilities and half mental disabilities, sort of showing how this is impacting folks in Connecticut. The Fair Housing Center, along with the Connecticut Data Collaborative and other groups, has done some research on race and gender in evictions in Connecticut, which you can access at ctdata.org. So from 2017 to 2021, Black renters in Connecticut were over 3 times more likely than white renters to have an eviction case filed against them. And Latinx renters were over 2 times more likely than white renters to have that eviction started. And this is even more heightened for women. 62% of eviction filings for Black renters were against those headed by a female head of households. And the right to counsel data we have so far in terms of who's accessing right to counsel also shows that, it's predominantly tenants of color are seeking legal representation. 46% of Black renters are, those who've been assisted by right to counsel, and 32% of Latinx renters. There's a great quote from Matthew Desmond that I always go back to. He says, if incarceration has come to define the lives of men from impoverished Black neighborhoods, eviction was shaping the lives of women. Poor Black women were locked up and poor Black women were locked out, just showing how eviction does disproportionately impact Black women and come to define their lives. Eviction is a process. It's not just a single act. And it also follows after people, after an eviction is started or, they're actually removed from their housing. And then finally, like with families with children, of the folks who've gotten right to counsel, 49% have had children in the household. And we know nationally that more than 1 in 4 children in families living below the federal poverty line experience an eviction by age 15. So that's just a sense of who is impacted by eviction in Connecticut.
Thank you. Thank you, Sarah, for sharing that. So that's a little bit about evictions, but I did want to bring us back to tenant protections and open it up for a conversation to our panelists. What are tenant protections when you're applying for an apartment? And starting there.
Well, I think Marie-Claire referred to part of it when she talked about protections under fair housing law. Fair housing laws exist at both the federal and the state level. The Federal Fair Housing Act really provides the floor of protection, and states can choose to protect more people from discrimination, and that is something that Connecticut has chosen to do. I think one thing that's really important that not everybody knows is that some properties are exempt from the fair housing law. Federal fair housing law exempts smaller owner-occupied buildings of up to between 1 and 4 units. State fair housing laws, and Rafi and I just had a conversation about this earlier today, exempts owner-occupied 1 or 2 family homes. The thing that's important is that people are not supposed to be discriminated against if they are a member of a protected class. That does not mean or guarantee that discrimination won't happen, but what it means is that the law provides a remedy if it does. So the question becomes, what are the protected classes? Under federal law, it's race, color, national origin, religion, sex, which includes gender identity and sexual orientation, familial status, and disability. The state includes all those categories plus more, also includes ancestry, marital status, age, referring to non-minors, lawful source of income, which is key because that's all your sources of rental assistance, status as a veteran, and I think we already had a question in the chat, so I know we'll come back to it later, erased criminal records. The Connecticut Commission on Human Rights and Opportunities investigates discrimination claims under either the federal or state fair housing laws. And the only other thing I wanted to add before turning it over to my colleagues is that there are a couple of protections that domestic violence victims have. They're allowed to terminate a lease early if they give a landlord 30 days notice. And the other group of people who can terminate a written lease early if they obtain subsidized housing are people who are elderly or disabled. So if they're 62 plus or they're disabled and they finally come to the top of that waiting list for subsidized housing, they can give written notice to their landlord of 30 days and be able to move out and not have to keep paying on that written lease. So I do think those are things that help people when they're looking for apartments.
Oh, Rafi, if you're talking, you're on mute.
Thank you. I was talking. I was actually waiting to see if somebody else was going to say something. But Sarah, did you want to go ahead? No.
Right. I think I was going to talk just briefly about criminal record screening, which has already come up some, and also links to the Fair Housing Act. So as folks have probably seen, a lot of landlords will list policies like no criminal records, no arrests, no felonies, no misdemeanors, things like that. And there are protections that limit, what a landlord can do in that respect, but it really comes from the Fair Housing Act because of the disproportionate impact these policies have, especially on Black and Latinx tenants, because of over-policing, higher arrests, higher rates of incarceration in these communities, which we know is really about like these systems and the police and racism, and not about someone's suitability as a tenant. But this isn't like a law or a clear criteria we can point to. Unfortunately, it kind of comes from the Fair Housing Act, that this has disparate impact on these renters. And there is some HUD guidance on what a landlord should or shouldn't do, and what may violate the Fair Housing Act with regards to criminal record screening. The main takeaway is that blanket bans saying that someone can't have arrests, no felonies, no misdemeanors, no XYZ type of convictions very likely violates the Fair Housing Act. And if a landlord is gonna try to exclude people from housing based on someone's criminal history, they have to have a really clear justification, an important reason, and real evidence that this criminal history matters, which most of the time that evidence just doesn't exist. There isn't data to really back it up that someone who's been in the system or been arrested or convicted is not going to be a suitable tenant. And landlords are also supposed to look at individual mitigating circumstances. So what led to the conviction or arrest or whatever? What has happened since? What was it even for? And how does that connect to housing? Are there letters of support? Is there other evidence that this person would be a good tenant? So there are these criteria, but unfortunately, there's not a really clear law on the books in Connecticut that we can point to say landlords shouldn't ask about criminal history, kind of a ban the box type thing, or, codifying other forms of limitations. So that's definitely an area that could be expanded where the state could do more.
I was asked to say something about what's becoming more and more of a problem, which is the expansive use of eviction records as a screening tool for excluding tenants. And one of the things we've seen from the legal services angle is the extent to which people who are facing eviction and are willing to move, would like to move, cannot move because there was no place that will take them. And a lot of that comes from the fact that they may have an eviction record. One of the things we discovered during the pandemic was the widespread belief that if you have an eviction case against you and it gets withdrawn, that you will not have an eviction record. And that's simply not true. From the point of view of the courts, you have a record once a case is filed. If you move prior to the landlord filing paperwork with the court, you will not have an eviction record because no paperwork has been filed. But once that's filed, you will have an eviction record. So anyone who's doing checking on that will find that information. And there's sort of two principal sources. One is people who do it themselves by going to the judicial branch online directories. And the other are screening services that are hired. The bulk of screening that goes in, it's my understanding at least, is through screening services. Landlords by and large are not doing their own screening of records, but they're hiring a screening service to do it. The judicial website right now, and protections on that are very, very limited. So let me just say it that way. The judicial branch website right now holds on their records publicly available for a year withdrawals, dismissals. They hold 3 years on their public records for judgments, not only judgments for the landlord, but judgments for the tenant. So even a tenant who wins an eviction will fall into the 3-year category. But what we've learned is the judicial actually has a different database that is used and is marketed or is made available through sale to screening companies. And that is a permanent base that does not remove people at the times the public database is removed. And under federal law, the screening services can go back 7 years. So if you're working through a screening service, you will find a 7-year history. The problem with easy availability of eviction records is they're simply not reliable. The judicial branch actually has a disclaimer on its website urging that people not use its website for tenant screening purposes. And that's because typically people doing screening look to see if a name is there, but do not look to see what happened in the actual eviction. Why was it brought? What was the nature of the result? Was it a two-sided, worked out, negotiated agreement? None of those things get looked at. So in terms of remedies and protections right now, I would just say that they're fairly minimal. Tenant screening services are subject to the Fair Credit Reporting Act, and there are some remedies, but the main remedy under that act is that you're supposed to get a notice that a screening service has been used, and that you have the right to ask that your record be corrected if it's incorrect. But that's not used often, it's not effective, it's not timely. And the reality is it may not be inaccurate, but the issue is how you handle it, how you weigh it against other things. So that is an area where over the last couple of years, people have looked legislatively to see if to look for possible ways to mitigate the impact of that.
Thank you. And we'll get a little bit more into some of the policy gaps and areas to explore towards the end of this conversation. But we talked a little bit about some of the tenant protections for when you're applying for an apartment. I want to expand on that and ask about what some of the tenant protections are for when you're living in an apartment.
That's a great question, Danielle, and I can start. And I really want to take us a little bit because the concept of reasonable accommodations also applies when somebody's looking for an apartment. If somebody has come up and they have that record, they have that criminal record, or maybe they have bad credit, or maybe they have an eviction record, but the reason for that negative mark on their record is attributable to their disability, and they are now dealing with whatever had happened in the past and are in a better place, they can ask as a reasonable accommodation of that disability that the no be turned into a yes, because that allows for people to have access to housing. The same is when people are accused of something that could result in their eviction from an apartment, and the behavior is disability related. For example, a lot of the things that we deal with at Connecticut Legal Rights Project are people who are exhibiting symptoms of their mental health condition. Maybe they're making noise, maybe they're disturbing their neighbors. Maybe their apartment is more cluttered, but not to the level that it's an actual safety hazard as documented by a building official. It's just more cluttered than maybe the landlord or the property manager would like it to be. The person can ask as a reasonable accommodation that they continue to have access to the housing and that they not get evicted. And that's something that can be requested at any point in the eviction process. It's always better to ask for something like that as soon as you have the first indication that there might be a problem, because it just gives you more time to have the conversation, the interactive process with the landlord. But it's supposed to be an individualized assessment. There needs to be that nexus, a connection to the disability. And they're not going to be obligated to accommodate a direct threat. A lot of times we have clients who are accused of committing serious nuisance, and really they're annoying, but they're not dangerous, and they're not presenting a danger to the health and safety of other tenants or the property manager or the landlord. And that's really what a serious nuisance is. The analysis of whether somebody consisted of a direct threat is not supposed to be based on prejudice against people living with mental health conditions, which too often it is. So reasonable accommodations under the Fair Housing Act is one way that people can stay housed in their apartments.
Rep. Hugh Williams, I'm not sure. I know there had been a question and that had actually come up in the chat around, is Connecticut heading in the direction of putting rent limits in place to stop rising rents in CT? But I also know that there's been some conversation about rent increases and the Fair Rent Commission. So I didn't know if you wanted to jump in and talk a little bit about those.
So let's first talk about what we have been able to do. So last year we were able to implement a law that would require all towns and municipalities over 25,000 population to have rent commissions. These commissions are very low bar, easy ways to have stronger relationships between tenants and property owners. This is just a fair mediator that city councils and mayors can appoint to make sure that these conversations around the actual amount of rent, improvements to properties, timely payments, almost anything in the relationship between the property owner and the renter can be negotiated through these commissions. All municipalities are required to have them that are over 25,000 by July 1st of next year, but I would heavily encourage all of our towns, and even towns that are under 25,000, to implement these now. The need for these conversations and for these mediations are not just today, but for the last year or so, and probably even longer than that. So to wait for July is way too late, and those should be implemented now. And there are, I think it's close to 20 different factors that these commissions can look at. And I think 18 of the 20 are all market-based solutions for how to see what is considered fair and what is not considered fair. So I would heavily encourage our municipal leaders to implement these commissions, no matter the size of their town. And then to answer really quickly about where we're going, I think everything has to be on the table, whether it's around rent control, whether it's stabilization, other ways of doing deposits. I think everything has to be on the table right now. There is a clear need to give additional support to residents here in the state of Connecticut.
I guess what I just wanted to offer was some of the existing tools to deal with substandard housing. The most obvious one is municipal code enforcement, and people should be encouraged to use that heavily. Larger towns pretty much all have housing code enforcement agencies. Everybody has to have a health director, so even the smallest towns have someone who's responsible for enforcement to make sure that certain minimum conditions are met. The advantage to that from the perspective of a tenant is that there's statutory protection against retaliation, and that it's also free. You don't have to have a lawyer. You don't have to pay a fee to do this, and so it gets you out of the eviction kind of process where you're addressing these issues directly and getting a third party in, and a third party that's essentially neutral. Presumably the mission of the third party, the local government, is to maintain standard conditions and get rid of substandard ones. So that's not neutral, but it's neutral as between the landlord and the tenant. So that's, to me, that's the major thing. There is a provision in Connecticut law in which a tenant can initiate an action in court in an inexpensive way. It happens once in a while. It can be done by a tenant as a way of essentially eliminating the need, eliminating the risk of eviction. The tenant has to pay rent into court. The reality is tenants do not initiate litigation against their landlord while they're still tenants. It's unusual. So it's a useful remedy, but not one that's used very often. Fair rent commissions in the towns that have them are themselves another way of improving the quality of housing, because it's very common for fair rent commissions in looking at what might be structured as a rent-based issue to also be saying, well, is this a reasonable rent in light of the maintenance of the property? And typically a fair rent commission will ask this town's housing code agency to go take a look at the property and see if there's anything that needs to be brought up to minimum standards. And the last thing I would say is what some people see as the obvious remedy: just don't pay the rent. I personally do not recommend that, because it walks people into evictions, and the eviction forum, the eviction field, is not a level playing field between landlords and tenants, because the risk is so high for tenants if they lose. If you withhold rent and you don't satisfy the judge that you had a really, really good ground for doing that and really substantial basis, you will end up losing the eviction and you'll be out. You can't correct it after the eviction's over. You can't say, oh, all right, fine, now I'll pay the rent. It's too late at that point. So as a general rule, I would not recommend using that as a tenant remedy, or certainly not as a primary tenant remedy, but to work around other things. And I think coming up is maybe we'll talk about tenant organizing, but that is an important way to address some of these issues.
Yeah, Rafi, I'm going to pick back up on that and talk a little bit about tenant organizing and collective strategies to deal with problems in your housing. I think all of the processes we've talked about are very individual, but as we know, like if one tenant in a building is having problems with their unit or facing a rent increase, most likely everybody is. And basically the idea of tenant organizing is people are supporting each other in working through these processes. And also because, you know, one tenant fighting back against the landlord may not make that much of a difference. A bunch of tenants coming together, supporting each other, coming up with a strategy, maybe all complaining to the Fair Rent Commission or all doing the action to pay rent into court, could have an impact, not just in fixing one person's unit, but in fixing the complex as a whole, all of the problems, and giving people more of a say, you know, in what their housing looks like. And I will say, like, one of the most exciting things to me of the past couple of years has been the huge resurgence in tenant organizing in Connecticut. A lot of folks doing that work are on this call. I saw Vanessa from PT Partners, Camilla with Haven Lee, Teresa with Make the Road Connecticut, and my colleague Maria, who also organizes along with me with Connecticut Tenants Union and DSA, and so many more folks in Connecticut are coming together, whether they call it a tenant union or not, and figuring out strategies to, you know, not be so alone in the problems that they may be experiencing with their landlord, whether that's conditions or evictions, and finding ways to get things changed together. At this point, you know, we do have some limited protection from retaliation in Connecticut for tenant organizing. There is a law that prevents landlords from increasing rent, decreasing services, or evicting someone without cause within 6 months of them organizing or joining a tenant union. So that's something. It kind of has to be used defensively or through a fair rent commission, and only lasts for 6 months. What we're lacking, I would say, are an affirmative right for tenants in private housing to organize and form a tenants union or a tenant organization, access to common areas to have meetings, access to resources, to get into buildings, to talk to folks. None of those currently exist. In terms of what's available and what's happened to other places, something I've been really interested to see is San Francisco has recently passed an ordinance recognizing tenant unions and requiring landlords to bargain with tenants like they would do in a labor union once they reach a certain percentage of membership. So tenants are guaranteed that seat at the table and a say in what's happening with their apartment and condition. So there are definitely some ideas there. But I would say with many, and also in New Haven, they're considering an ordinance that would recognize tenant unions with their fair rent commission. So a tenant union could request an investigation into a building, have representation from an organizer with the union, and then, people could file fair rent commission complaints to get their rent lowered based on those sort of collective findings.
Thank you all. This is an awesome conversation. Our audience too is asking questions that are right in line with the questions we had talked about uplifting today. So I know somebody had asked in the chat, but we also wanted to raise it in this conversation as well. But I'll turn it over to all of you. What are the tenant protections surrounding evictions? So if you are facing an eviction, what tenant protections might exist for you?
Well, I will give the probably 60-second overview of evictions. I think the most important tenant protection that tenants have is that right to be evicted. And I know it sounds very strange to describe getting evicted as a right to have, but what it does mean is that a landlord can't just come and change the locks or remove your stuff and remove you physically from a unit without going through a court process. I did see a question in the chat, like, does getting a notice to quit mean you have an eviction record at that point? No, it doesn't. Most important thing to know about a notice to quit is it's basically one last request from your landlord to leave before they initiate that case in court. So if you actually do leave, then you won't have a case in court, but you're not obligated to leave. And if you don't have somewhere else to go, you might not have a choice to be able to leave because it just really isn't an option for you. So the most important thing is that there is a court process that the tenant does want to respond to, because if you don't respond to court papers, the court is going to think you either left or aren't interested in fighting, and the landlord can just keep that machinery moving along and eventually get an order for a marshal to put you out of the house or apartment, take your stuff, put it in city storage. And if you don't get your stuff out of city storage within 15 days, they can auction it off. That's why evictions really are violent. They really are incredibly disruptive to people, to families. And people lose a lot more than just the roof over their head. If you get anything in writing, ask for help right away. We'll be talking about right to counsel in a few minutes. One of my colleagues will. And the earlier you can get help, the better. There are always things that you can do, but just think of it like you're running a race with hurdles in it. The further along you get in the race, the higher the hurdles go, and they're harder to get over. And for you to get to the finish line of keeping your apartment will become more of a struggle.
In terms of what has to be shown for an eviction, Connecticut law requires that there be a cause, but cause is defined for that purpose in a very, very broad way, which is to say it's a cause that your lease is expired. It's a cause that the landlord has decided not to keep you. But we have a statute that they sometimes call just cause eviction, which in its present form protects seniors and disabled people who live in buildings with 5 or more units, sometimes called just cause eviction or good cause eviction. And it says what's really obvious when you think about it. You have to have a real cause to evict someone. If someone is being evicted because their lease is expired and is not being renewed, that's not a real cause. That just says, I don't want you to live there anymore. It doesn't explain why. Nobody gets evicted for no reason whatsoever. A landlord who does not renew leases, a person's lease is not renewing the lease because there is some reason why the landlord doesn't want to keep that tenant. There's kind of an implicit stability assumption, which is that once you're renting, you're going to keep renting and keep renting unless you do something wrong that justifies forcing you to move out, asking you and enforcing if necessary. So one of the important areas of Connecticut eviction law is defining what is a ground, what satisfies the requirements, and historically, nearly all evictions in Connecticut, probably 90%, were based on cause, most of them non-payment of rent. But what has happened, maybe signaled in some sense through the pandemic, is that landlords have increasingly decided to avoid having to prove anything, and have instead started using what they call lapse of time. That's your lease has lapsed, it's expired by the passage of time. That is a no-fault ground. And the result is they can prevail in eviction without having to give any real reason, which then makes it very, very hard for the tenant to be able to show they should be allowed to stay. So that's both kind of a new status. Is lapse of time evictions have increased significantly. The trigger was, to some extent, landlords who didn't want to take money from Unite CT, and this became a way of getting around that. They wouldn't plead, they wouldn't raise the issue of non-payment. They would simply go for lapse of time. But now that has become a problem, as a larger and larger percentage of cases actually are not giving a true reason. So that's something we're certainly looking to going forwards.
So I know we want to talk about right to counsel as well. I'm going to toss it into, I think, our last question, just so we can get to it. But I know we want to end the conversation really around what are some of the policy gaps and what can we work on accomplishing next. And I know, Q, we haven't had the chance to have you speak in a little bit, so I wanted to open it up to have you kick off that conversation, and then maybe we can build in a little bit about right to counsel into that conversation, if that's all right.
Perfect. Thank you for having me on this panel. I do think the number one thing that we need to do is build more housing, period. That is going to be the real way that we have housing at all budgets. And we can do several things that we can do to give developers access to being able to do that. And I think one of the number one things that I will be fighting for as a housing chair is allowing for developers like our housing authorities to do so outside of the municipalities. They have the experience, many of them have the capacity to do so. And this is not a demand issue. Many folks want to live in Connecticut or move to Connecticut for a lot of the great reasons that we have: wonderful universities, a growing economy, numerous businesses to work for, a transportation network that could be significantly better, but not terrible. These are all reasons that we want to live here. If we are truly going to be a state where there's a housing at all budget, it has to be by growing our stock. And the number one thing we can do that by is allowing developers to know what the rules are, empowering them to do so, and moving forward. And the other side that starts off with that, the other, I think, side of that coin, is that we have to look at our zoning laws too. And right now our exclusionary zoning is making it incredibly difficult for us. And we have to look at a more inclusionary sort of process if we want to have additional housing.
So I'll just share a little bit about right to counsel, which has been a huge victory for the tenants movement in Connecticut and for all of us that care about tenant protections. And this is addressing the disproportionality in who has legal representation in the eviction process, which is very technical and very hard for people to navigate on their own, which had been like 85% of landlords having a lawyer and fewer than 10% of tenants. And like what right to counsel does is eventually, guarantee that tenants facing eviction will have access to a lawyer to represent them, and is currently being phased in around the state by zip code. It's in 13 zip codes now, and tenants in those zip codes, if they get a notice to quit, that's that first document like telling them to leave, they can call and get access to a lawyer, and as it moves through the court process, have a legal representative, a lawyer to represent them through that. And we know from other jurisdictions, this decreases the eviction rate, even eviction filings and forced moves. And we're also already starting to see that some in Connecticut. Of the cases just so far since January, 53% of them where the tenant, had a lawyer, has resulted in the withdrawal of the case. So that means the landlord like yanking the case from the court, and 60% of the cases so far have prevented an involuntary move. So that's something that, as it's implemented, and we definitely need more permanent funding for, will start to address some of the inequality, the power imbalance between landlords and tenants, and prevent evictions. And just on other things we could do as a state, we talked some about good cause and just cause. Mary Claire did and Kathy did. This could be expanded to, protect many more tenants. So a landlord would have to have a reason to evict someone, and not just because they want you out or covered to discriminate against you, or they're mad that you've been organizing, or other things like that. That's something that was considered last session, and that, I think would help give tenants more security in their apartments as to organize, to just live there, and help drive down many of the evictions we are seeing post-pandemic.
Is there anything else our panelists wanted to add as it relates to policy gaps, or where there's opportunity for next, before we jump into some of the questions from our audience members?
Let's do questions.
I like it. We do have a lot of questions to get through. So I'm going to start with a quick one that I see here. Where is it? Does 47A20, I'm assuming that's some legal language, protect tenants without leases? I don't know if any of you can quickly speak to that.
Yes, the answer is yes, but you should understand something. Leases don't have to be in writing. The actual term in Connecticut law is rental agreement. If there's an agreement for the tenant to live there, then the tenant has a rental agreement. It can be in writing, in which case we think of it as a lease. It can be verbal, it can be in which case it's an oral month-to-month lease. But for purposes of landlord-tenant law, they're both in writing or not in writing. They have the full range of protections that go with tenancy in Connecticut. So something like 47A20, which is a retaliatory eviction statute, applies whether you have a written lease or just an oral month-to-month lease.
Thank you, Rafe. I want to uplift another question for our panelists. There was a comment, we as community leaders hear from some families saying that they can't apply for affordable housing due to their immigration status. Is that discrimination? Is that considered discrimination? And I'll start that conversation.
I mean, I think the challenge with that, if you're talking about, federally subsidized affordable housing, there are requirements in terms of eligibility where people may be required to be citizens, and maybe even if the head of household is a citizen, you may be able to have someone without documentation or who isn't a citizen as part of the household, but it just affects how the income, the rent gets calculated and everything else. So it is definitely hard. I think it's almost as if they wrote the law so it would be an exception, because if you look at fair housing, it does say ancestry, national origin should not be a basis for discrimination. And yet when you write the eligibility requirements in a certain way, you're kind of setting it up for that to happen.
If I can step in, I'll just add that this has been a significant problem, I think, for a lot of immigrant communities. And one area that has been helpful is where states step up and try to provide subsidies to immigrant tenants that would otherwise be closed out of subsidized housing through federal funds. And I think that's been especially during the pandemic, like one way where states have stepped up to fill in that gap that is otherwise really hard for families who needed housing during the pandemic and afterward.
Thank you. All right, there are so many more questions in the chat. Unfortunately, we're not going to get to them, but I did want to throw out a quick speed round question to our panelists. If there's any resources or places that you want to direct folks to learn a little bit more or expand on some of the conversations we had today, I want to leave folks with that information. So I'll just open it up in case anybody wants to share any resources or links.
Well, I think all of our organizations' websites have information about rights with regard to housing. You've got ctlawhelp.org. You've got evictionhelpct.org. I believe there's a new eviction guide that just came out, but I don't know the link to that, but I'm sure that we can put all that stuff together to an email that goes out to everybody afterwards.
Absolutely.
I'm going to include my email address in the general chat. I would say if you have ideas for what policy should look like, I think those that are closest to the issues are also closest to the solutions, as the great representative from New Haven, Robin Porter, also would say. So if you have ideas on how to fix these policies, please just send them over and we'll see if we can get those implemented.
Thank you so much. And thank you so much to all of our panelists. I hope you're all enjoying a silent round of appreciation and applause from your virtual audience members today. Thank you so much to everyone who participated. I really quickly want to remind you all to join us this November. We'll be hosting our Affordable Housing Conference, November 14th, 15th, and 16th. Registration is not live yet, but it will be in the next month or so. So keep an eye out for that, but please save the date. You can visit the link shared here on our website to learn a little bit more as more information becomes available. We also have a closing question for you all. If you can take a moment to answer, just provide us some thoughts or insights on what you'd like to see covered from future IForums. There's a lot of great content that we can cover, but we want to hear from you on what you would like to see. And with that, I thank you all for joining us today for this conversation. There will be more conversations like this and on other affordable housing topics at our conference in November. So we hope to see you there as well. And thank you again to our panelists and our keynote speaker today for being a part of this important conversation. Thank you so much for joining us.